Welcome, everyone. Appreciate you coming out today. And my name is Joe Lawson. I'm the Deputy Director at the Harris County Law Library. It's my pleasure to welcome you today to our next installment of the Legal Tech Institute Lecture Series. And today's program, of course, is Legal Tech is Not Optional. And of course, we know that, right? There's now an ethical duty in Texas to stay on top of legal tech. That was earlier this year. We also have different technology requirements imported to the rules of civil procedure. And if you practice locally, you know that the 247th Family Court has a requirement to submit things as an Excel spreadsheet. So regardless of where you're looking and your legal duties, you'll find some sort of requirement out there. And that's why the Law Library offers the Legal Tech Institute, to make sure that there's learning opportunities so that you can comply with those various things. And a lot of the inspiration behind, for example, our Excel or Word for legal work programs comes from the Legal Tech Audit, which was created by today's speaker. So if you've taken any of our classes, you've probably heard us talk about that and extol the virtues of our speaker today. But just for anybody who hasn't had the pleasure of joining us in the Law Library Thursdays at 2 o'clock, let me tell you a little bit about Casey Flaherty. He's a principal at Procertas, and that's the company that he's formed to make the legal tech assessment available to everyone online. And you can pay for it yourself if you like to, but the Law Library has actually partnered with Procertas to make a version of it available for free in the Law Library. So if you want to learn more about that, we'll actually be demoing that on the computers in the back after the program. And you can ask one of our law librarians to give you a quick tour, or maybe even Casey himself if he's inclined. Additionally, Casey was recently named the Director of Legal Project Management at the global firm Baker McKenzie, although he's not here in that capacity today. I'll make a note of that. Casey is certified as a Lean Six Sigma Black Belt, which he pours into his work, improving process management in the legal field. He's also a contributor for the local blog, 3 Geeks and a Law blog, and we have another writer here, so Greg, if you want to raise your hand if you have any complaints. See Greg, don't see Casey. Casey has also been named Fast Case 50. He's been recognized for his innovations and visionary leadership in the realm of legal technology and law practice management. He was named a Legal Rebel by the ABA Journal, and he also won a Vendor Champion Award for Procertas from the American Association of Law Libraries. So he says that he doesn't put much stock in those things, but I think that all of those accolades speak for themselves. So I wanted to tell you all about those. So without further ado, let me hand it over to our speaker today, Casey Flaherty.
Hi, I'm Casey. Apparently I have virtues. I didn't know that. Someone should tell my ex-wife. So this is probably the most ubiquitous lie we tell in the modern world, I think. At least it's the lie I tell most often. I know a lot of lawyers in this room, but most of you just click I agree, because what else are you going to do? So this is the most common lie, or at least one of them. This is right up there. Now it's not quite a lie. It's an untruth. They're not the same, but it's quite common and true just about as often. And I'm here to convince you, A, that this isn't true, and B, the fact that it isn't true is actually important. It's important to the practice of law. And that is because the distribution of users' computer skills are worse than you think, and this matters. But I'm not going to start there, except to say that I have validated this myself. We've mentioned Procertas. I've tested about 15,000 law students, lawyers, admins, paralegals, what have you. It's worse than you think. And that's not anybody's fault. It's simply a case of just because you have the tools doesn't mean you know how to use them. And technology is very much the case of the tool that you need to learn how to use, at least to use well. But let's not begin there. Let's start more generally about law and how lawyers have traditionally approached problems. And there's nothing wrong with it, which is that when a lawyer attacks a problem, they apply a lot of learning and a lot of effort to try and get the right result. And if the particular problem they're facing is too much for them, normally what they do is then add another lawyer, and another lawyer, and another lawyer, and another lawyer, until they have a law firm. And we've been doing this a lot. And there's nothing wrong with it, except that it does not scale. You can only do this so much. And that's because lawyers at core are complexity engineers. Some of us create complexity, a lot of us solve for complexity, and complexity increases with, for example, the size of the economy. So here's an easy example of increasing complexity. Over a 20-year period, the references in corporate 10Ks to regulations quadrupled. 10K, as you all know, sorry, I spend a lot of time with law students, is a corporation publicly saying, here are the things that affect our business. Regulations have affected them more and more. But it's not just that the number of references to regulations has quadrupled. The variety of regulations has tripled over the same period, which is, that's governments dealing with increasing complexity, is adding complexity. And that means complexity has a very interesting characteristic. It's not linear, it actually compounds. And so the complexity that we're talking about has gone up exponentially over the years, and so has the demand for lawyers. Since the middle of the 1970s to today, the demand for legal services has quintupled, and that's as a share of GDP. So the share of GDP that went to pay for legal services quintupled since the middle of the 1970s because demand outstrips supply. And this is good if you're a lawyer for the most part, especially at a large firm. Since they started tracking such things in the middle of the 1980s to the Great Recession, large law firms grew at 8.9% compounded annually, which is insane because of the word compounded. 8.9% over a 30-year period. Great if you worked at a large law firm, which I happen to. The thing is, again, it's not sustainable. You can only do this so long. And so what has the main purchaser of these types of legal services done? They've brought it in-house. And so the biggest story in legal, and I do mean the biggest story in legal over the past 20 to 30 years, is the growth of in-house departments. You can see it here in chart form as in-house is taking more and more of the share of spend. But you can really see it here. Since the middle of the 1990s, in-house departments have grown at 7.5 times the rate of law firms. There are now more in-house lawyers in the United States than there are lawyers in the domestic offices of the AmLaw 200. And this is the big statistic. And corporations with one or more in-house counsel now account for 55% of the purchase of all legal services. So in-house counsel are the largest block of suppliers of business legal services and the largest buyers of legal services, period. And so this has been an amazing story, and of course, like all amazing stories, it comes with all kinds of hyperbolic headlines about how, big law is doomed. And again, I'm coming at it from the big law perspective because that's my background. I was in-house counsel before. We'll get to that. And from the in-house perspective, it looks like this. All of a sudden, we have much more sophisticated buyers, and our realizations have gone down. For those not familiar, there's the hours I spent, the hours I recorded, the hours I billed, and what I actually get paid. The difference between what I recorded and what I get paid is realizations in this context. But what's happening for big law isn't just happening in big law. The picture's actually much more dire when you get to small and solos in terms of how much time they spend on whatever it is they do and what they actually get paid for. And so there's a symmetry here, and it's not exact. It's not a perfect symmetry. But this is an industry-wide trend of people spending more and more hours and getting paid for fewer and fewer of them. Again, big law, it's realizations. A huge part of the realizations drop is this. It's discounts. Hey, I'm an in-house lawyer who used to be at a law firm. I know how inefficient you guys are. I know you're not worth $800 an hour, so I'm only going to pay you $600 an hour. Consider that a tax based on your inefficiency. And we see this all over the place. It's okay. I actually don't like it as an approach to relationship management, which I'll get into, and it's because of this. Right now, and I know this is true everywhere, but in-house lawyers will ask large firms for discounts and small firms no matter what. The thing is, when you ask for a discount no matter what, the signal gets lost in the noise, because maybe you're just asking for a discount because you want a discount. Maybe you're just asking for a discount because you're in the habit of asking for a discount. Hey, you're inefficient is just an excuse, or not. How does anyone know? Because they're asking for the discount no matter what, and the discount is not going to change if you get more efficient. And so the signal gets lost in the noise, and that to me is a big thing of what we lack in legal, which are appropriate feedback mechanisms. The discount is a poor feedback mechanism. We have bad feedback loops, and because we have bad feedback loops, we have bad systems. We have bad systems for relationship between clients and their lawyers, and then we have bad systems internal to the delivery of legal services. And that's where I've long been focused. He mentioned the Lean Six Sigma Black Belt, whatever that means. But this idea of how is it that we leverage expertise through process and technology? Now, that's not to discount expertise. Expertise is still central to what we're doing. It is the threshold consideration. Right? If you're a bad lawyer, none of the rest of it matters. But if you're a good lawyer, how we leverage that matters quite a bit. And in fact, over time, that's what changes. I spend a lot of time with law students, and no offense to them, but they're not going to be any better than the lawyers who mentored me when I was a young lawyer. Those lawyers were fantastic, and the lawyers who mentored them were fantastic. We are incrementally not becoming that much better of lawyers. So what can we get better at? We can get better at the way we leverage legal expertise through process and technology. And that gets scary because now all of a sudden we're talking about it's a very different language, right? It's not the language of law, it's the language of business, it's the language of engineering. And in the context of corporate clients and law firms, again, that's where I tend to sit. They don't discuss this well. They don't deploy that vocabulary particularly effectively. You know, they're talking past each other. And so my insight, to the extent I've ever had one, was that people in price are relatively stable. Corporations go back to the same lawyers over and over again, or they go back to people very similar to the people they've always used over and over again. Price, while we have all these discount discussions, actually stays within a pretty narrow band. Whether you're doing billable hours or flat fees, they look very similar. And even we have, every now and then we have a repricing moment, like the Great Recession. But with people in price in place, it's process that offers the most levers to drive continuous improvement. Again, how are we leveraging expertise? And so I wrote a guidebook on this for corporate counsel. I myself was corporate counsel, partnered with a bunch of other people to write a guidebook on how to have data-driven dialogue around service delivery improvements. This question of how legal work gets done. Maybe you can tell by now, I'm a little wordy. I'd be a great Bond villain because I monologue. I then shrunk it down into a primer. Same content, just went from 80-something pages to 6. But the basic idea was, again, we should have data-driven discussions about how legal work gets done, and this isn't about gotcha. This isn't clients are good and law firms are bad. It's how can we work to get together to better deliver legal services. And I showed you that realizations chart. Because realizations are low, we're not playing a zero-sum game. There's actually a lot of room, at least in the corporate space, for clients to spend less money and law firms to make higher profits. It's all very kumbaya, win-win, and I had to write the book in the primer because until I did, I was the word guy. I was the former snot-nosed associate at a large firm who then went in-house at a corporation and said, hey, there are lots of things I saw that I don't want to pay for. And none of them had to do with legal expertise. I had profound respect for legal expertise and I valued it and I knew we had to pay for it. But there was an entire infrastructure that I saw from the bottom that I knew was deficient. And that I didn't want to pay for. I saw massive waste and inefficiency. And to me, it was a puzzle. I was interested in lots of things. I was interested in automation and knowledge management and whether or not they used allied professionals like the professional researchers that we call librarians. There were all kinds of things that I was worried about, and almost none of them got any attention whatsoever, except for the fact that I came out and said, hey, you know what? Lawyers suck at work. And so that's what got the attention, and it got the attention because at the time it was called an audit. I dropped that because the word audit makes everyone nervous, but really that's what it was. As in-house counsel, I would take the invoices that I was sent by my lawyers, and I would read them, and I'd categorize them, analyze them, and then I would walk into their offices and say, show me. And they'd say, what, you want to go to a conference room and we can show you a PowerPoint about how great we are? I'm like, no, I'm going to sit with the people actually doing my work, and I know what work they're doing, and I'm going to ask them to show me how they're doing that work. And again, I was interested in automation, delegation, security, all these things. And after I would do this, and I did it as an in-house counsel, and then I went into consulting for many years, and I was paid to do it by large corporate departments. I've been on site at over 50 law firms doing this. I almost have the same conversation almost every time. I'm done, and I walk into the managing partner. Now sometimes it's the office, sometimes it's the whole firm, sometimes it's just the group, and they'd be like, we know, we failed. Those idiots in IT never give us what we need to do our job. But don't worry, we have formed a committee of partners on technology. So the next time you talk to us, it's going to be the blockchain and the Internet of Things and artificial intelligence everywhere you look. It's going to be amazing. So I know we're bad at the AI and the blockchain and all of it, but it's going to get better. Like, well, kudos to you. So here's the problem with technology is it doesn't stop. And so you probably always do need to be investing in some way in your technology infrastructure. And so I'm not going to come here and tell you, partner, that don't worry, stop investing, you're fine. But the truth of the matter is, you're fine. Like where you're at today is probably where you're at today, and there's a few areas where you could get better, and that's going to describe every law firm and business on the planet. That's not your main issue. Your main issue is the tools that you're giving people they don't know how to use. Like, well, what do you mean? Like, well, your associates don't use Word well. What? Yes, they do. Really? How do you know? Well, I mean, they're smart and they're young, and they're smart and they're hardworking. I'm sure all of those things are true. That doesn't mean that they know how to use Word well. And here's the thing, they didn't believe me on that part. You know, I could have gone in and given them a lecture on their data security and AI, and they would have eaten it all up. But you tell them that the kids are bad at Word, and they simply do not believe you. And so I had to create a test, which I did. And by the way, I hire a lot of people these days, and I use a test on people. I do actually believe this. Because this was the only way I was going to get data to actually support my opinion, despite the fact that I was right and they were wrong, This is the only way for me to prove that they were right. And what have I found? Of course, it's worse than you think. Even when you factor in, it's worse than you think. This isn't my data right here. This is from the OECD. The OECD did a 5-year study across 31 advanced countries with over 220,000 participants. And this is what they found about the distribution of users' computer skills. When it came to a medium complexity task that you should solve with technology, most people were poor to I can't even. That's where most people fit in. Very few people even had decent skills, and there was a very small percentage that were really good. What's an example of a medium complexity task? Control F. So for those of you in the room who know how to use Control F, you're laughing because, of course, that's totally obvious. Everybody knows Control F. And for those of you in the room who don't know what Control F is, you're like, what are you talking about? What is this thing? And this is the problem. It's actually two problems. Number one is the curse of ignorance. You don't know what you don't know, including Control F. If you don't know Control F exists, how are you supposed to know Control F exists? But we also have the curse of knowledge. Once you know something, it's really hard to imagine not knowing it. And so there's the people who know, assume that everyone else know, and then the people who don't just move along in blissful ignorance. Oh, maybe not so blissful, but definitely ignorance. What's a good example in the legal space? Well, lawyers love contracts, and by the way, even you litigators love contracts. You just call them settlement agreements. They're still contracts. Lawyers love to do two things in contracts. One is tweak them. There's actually really good data on this from the M&A space about people just tweaking things willy-nilly just to show their value. I wrote a 3 Geeks post on it. It's something about lawyers being copy and paste monkeys. That'll probably come up if you Google that. So love to tweak contracts, but they also love to refer into the contract itself. So cross references. You know, should this contract be terminated, the following provisions shall survive: 3.3, 4.2, 5.7, so on and so on and so on. Well, the thing is, these go together, because if you're always fiddling with the contract, then you have to change all those cross-references. Now, they weren't the first ones, WordPerfect was, but over 25 years ago, Microsoft is like, oh, you guys do this a lot. Let us give you a button to automate and update all those cross-references. What percentage of legal professionals working today know how to use this feature that's been around for 3 decades and applies to documents that they work on all the time? So I put less than 5% because it's a total hedge, just because I've been changing the methodology for a long time. The real answer is about 1%. About 1%. And this matters. And it matters not just because you should use the feature because it's available and you're spending 10 seconds instead of 2 hours. It's about what happens in those 2 hours. In those 2 hours, and these are for really long contracts, you have an enormous opportunity to make errors. And why are you making errors? Because you're bored. Because this is a highly repetitive, low value added task that bores you out of your mind. This is not why you went to law school. It's not why anyone went to law school, but you know what? It is actually necessary to get the document right. So there's an example. I mean, but we can use simpler examples like, I don't know, track changes, kind of a big one, redaction, kind of a big one. But maybe Georgetown law grad, Mr. Manafort, he just hired a bunch of clowns, and it's just them. Or maybe this happens all over the place, no matter what firm you're going to, and how high profile and technologically sophisticated the client. Happens in Word, and it certainly happens in our friend Excel. I'll give you a second just to read the highlighted part. Yeah. So, you know, no biggie, right? And that's because I think we make a mistake, and that mistake is very much about that curse of knowledge. We assume people know things, and in fact, it isn't even the curse of knowledge, because even if we don't know it, we assume that someone else does. And you know who that someone else is? Young people, the digital natives. You know, they get their Instagram account in utero now. Of course, they know how to use this, but that's actually the wrong way to think about it. The thing about apps, single-purpose apps, is they are, in fact, simple. They do that one thing well. And you never learn how to navigate menus and settings and do all the kinds of hidden things that actually matter, that actually translate into a modern environment. The point of most of the technology we use in our day-to-day practice of law is that it is not, in fact, intuitive. Or it's intuitive to a point. And we should talk about why that is. Why can't what we do be more like Google? Google's amazing. 3.5 billion times per day, some of us put in some keywords. And in less than 1 second, the Google algorithms will rank 60 trillion web pages. And only 0.1% of us are ever desperate enough to go to the second page of results. That's pretty profound, right? And yet, it may surprise some of you to learn that Google offers 2 6-week courses on how to use Google. And that is because once you get past basic keyword searching, Google looks a lot more Boolean. It looks like what you're going to do in your more advanced legal research technology. You start to learn about connectors and punctuation and all these other things that can really hone in your research capabilities. And of course, Google could design a user interface that crams all of this functionality in, except they would sacrifice their hallmark minimalism. So what have they done to cut this Gordian knot? They've done what almost all software does. They have a basic user experience that works just fine for basic users, and then they reward power users who truly learn how to use it to its full capability. But they actually have to learn. They're not born knowing it. They don't know it because they have a smartphone. They don't know it because they've been playing video games. They don't know it even if they've been a software engineer for years. They have to learn the specifics of this particular program. Now, the deeper their background, the higher their baseline, the easier it is for them to acquire, and some of it does become intuitive. But if you're starting out from a low baseline, it's really, really hard. I would submit to you that Microsoft Word is very much the same. If you want it at its most basic, a typewriter with a glowing screen, it's fairly intuitive. You open it up, you start hitting the keys, and the words appear. But once you want to start doing something more complex, like put together a contract, all of a sudden it's a lot less intuitive. Word is not a single-purpose app. It is an app ecosystem, and all these little buttons are apps. And we actually have to know when and how to use them. My basic point is there are very few easy buttons in the modern enterprise environment. We're building more and more all the time. Aspirationally, we should continue to try and suss them out. Anyone who's into UX and UI and programming, go with God. I'm a huge proponent of making things simpler, easier, faster, more powerful, etc. But the truth is, today, most of the software we use is at a level of complexity where we actually have to learn it in order to use it well. And if we don't, we are going to be very, very frustrated much of our time. For me, this is a really important slide. It comes out of studies from MIT that suggest for every $1 a business spends on acquiring technology, we should spend up to $10 on personnel, process redesign, and training. We want purchasing the technology to be the end of the story. Just buy it, and then everything is fixed. And instead, it is the beginning, such that we have an enormous expectations gap. Buy it, everything gets better immediately. No, no, no. Buy it, everything gets worse. And it really does. It gets worse before it gets better. There is always an implementation dip when you ask people to do things differently. Now, the dip doesn't always have to be deep, but it is always there. And it definitely defies our expectations. In fact, it can confound our expectations so much that it makes this chart wrong in a very fundamental way. So the chart I just showed you implied that every improvement initiative bears fruit eventually. Maybe there's a deep implementation dip, but eventually we get over it and it bears fruit. Not really. A lot of the time, we get something new, we try and do something new, we get frustrated, and we go back to doing it the old way. Because why? The old way worked. And we have work to do. And so we just need to get it done because we have deadlines. We live in an environment where we need to get things done. And so I don't like this chart either because I don't actually think people are scared. I don't buy into the whole technophobic lawyer idea. I actually don't buy into age and technophobia. I really do think that people are busy, and when they are busy, they make decisions driven by their urgency, and that is completely understandable. But it does lead to a lot of suboptimal outcomes. Our machines aren't sentient yet, but I believe once they achieve sentience, before they go Skynet on us, their very first emotion will be frustration. As frustrated as we've been with them, they'll be even more frustrated with us for misusing them all these years. And this has real world consequences. Young lawyers in particular are miserable. One of the main reasons being older lawyers. But an even bigger reason being that we sit young lawyers down at machines that we think they know how to use, that they've never been trained on. And there they are, chained to them 12 to 20 hours a day. And it's horrible because they spend a lot of their times doing things like updating contracts and the cross-references and saying, wait, a client's paying how many dollars per hour for this? I went to law school for this. This is miserable. It is also boring. Law is literally the most boring job in the world because there's a lot of drudgery inherent in what we do. Much of that drudgery can be automated. In fact, much of it has been automated. But our technology, like our cars, isn't yet self-driving. It can get us from point A to point B, but it still requires precise user inputs. We know what the rate limiting factor of today's technology is. It's us. And that's why I'm such a huge proponent of technology training for everyone, but in particular for legal professionals. This is the world I know best. It's the one I can speak to with the most authority. I'm sure this is true everywhere else. All the studies suggest it's true everywhere else. But I can say with a certitude that it is true here in legal. Now let me tell you what's wrong with technology training. And actually training in general. Availability and learning are not the same thing. Track changes, redaction, cross-references, you can Google those right now and learn how to do them in Word. It's all available to you, but are you actually going to Google it? No, because you don't know what you're Googling, because again, you don't know what you don't know. All of us, including me, in some aspect of our lives, reside here at the peak of Mount Stupid, where we labor under delusions of adequacy. We have unjustified confidence in our own competence because we don't know any better. That's okay, except when it isn't. And frankly, I get presented as an expert with all kinds of virtues. I'm really not that far along the curve. I just got far enough to recognize how little I know and how much low-hanging fruit there really is. But even when you understand that, even when you come to a talk like this with a speaker like me who's like, he's right, you go back to your desk and there's still this gap, right? There's the knowing, what they call it the cap gap between knowledge and practice. There's action, and that's a hard one to bridge, again, because learning takes time. Very few of us are on deadlines to get better with technology. Every now and then you'll see an interesting disciplinary action for a lawyer where they are in fact on a deadline to get better with technology, but that's extremely rare, right? That's an outlier event. I speak at a lot of legal innovation conferences where you always see this cartoon, and in the beginning I thought it was hilarious. Dumb lawyers, we're trying to make their lives better, right? Why won't they let us? I've stopped liking this cartoon because I think it's more like this. You have to understand context. You have to understand pressure. You have to understand, what am I actually responsible for? And if I am responsible for getting to the rocks to the top of the hill right now, I'm just going to drag them because it needs to get done. And unless we create the space for people to learn, most people are not going to. So learning does take time. That said, time also doesn't equal learning. If you had come here today and I had stood up here and I demonstrated Word for an hour, you would retain almost none of it. In part because you would have been looking at your phones the entire time, because that is dreadfully boring. I've written some colorful articles. I think the headlines are like, why CLE sucks, or making CLE suck less, or something like that. I actually don't object to lecture-based formats for CLE. For getting across big ideas, perfectly reasonable way to do it. I just don't like CLE when it comes to imparting technical skills. It's not the best way to do it. And we'll get into that later. Normally, this is where I break into the whole, this is what Procertas does, this is what I've designed. That'll come at the end. We'll do it even after Q&A for anyone who wants to stay. But I'm a big believer in creating mechanisms for transparency and accountability, and that's why Procertas gives micro-certifications once you demonstrate you're able to do things. Not because you sat through some lectures, but it's based on, it's competence-based learning. It's competence-based learning that actually was just awarded a CLE accreditation in the state of Texas. Speaking of the state of Texas and states in general, there was a reference to 1.1 comment 8 and how that's being adopted all over the place. Just for the record, duty of competence is not the only ethical duty implicated by using technology. Duties related to reasonable fees towards your clients, not only reasonable fees, but being a supervising attorney, not only to other attorneys, but to, and I hate this word, non-lawyers. It's in the rule. Otherwise, I talk about allied professionals. This is spreading. We're at 36 states so far. The state where I'm barred, although I live in Austin, the state where I'm barred is California. You'll see they're gray. Their bar said, we don't actually need to change the rule. It is implied in the rule. And in December of 2015, they wrote a formal opinion saying that the duty of tech competence is there, and it took 3 months for it to be cited in a sanctions opinion against a senior partner. Now, this happened to be e-discovery, and the partner said, whoa, I gave that to the associates and the vendor. And the court said, yeah, no. The duty of competence is non-delegable. You have to be competent enough to oversee it, or you have to bring in someone who can actually oversee it. You can't leave it to your associates and the vendor. So California hasn't adopted the ethical rule, but lawyers there already understand that it's part of the rule. This is in part about specific skills. People should get better. People should learn how to do specific things. They should learn cross-references, track changes, redaction. But it's also about a mindset. As you raise your baseline with technology, the better you understand it, the more you'll have an intuitive sense of what it should be able to do, which doesn't mean you know how to do it. All it means is that you can look it up, that you can Google it, that it's not so much about going from 4 hours to 4 seconds. It's going from 4 hours or 2 hours or 20 minutes or whatever it is down to 2 minutes. And it might only take you 4 seconds to do after it took you a minute and a half to look up. That's okay. That's still a massive, massive improvement. We don't all have to get to expert level, but we absolutely need to increase our baseline. And you're still not going to be a good lawyer. I mean, you might still be a good lawyer, but you're not going to be a good lawyer because you're good at Word, or because you're good at Excel, or because you're good at PDF. But it is more and more table stakes. It is table stakes for doing what you need to do to practice law, or do what you need to do to be a legal professional to support those who are practicing law. And it's only going to become more so as time goes on. There's this weird thing where everything is the same but also completely different. This is St. Peter's Square about 8 years apart. The people are still there, and they're there for the same reason, the Pope, and yet it's completely different, but the same. And that's at least how I feel about the practice of law. It's how I feel when I talk to my mentors about when they were coming up. Everything's changed, but not that much has changed. I know I'm not articulating it well, but that for me, that's technology, right? It becomes it becomes core to what we do, and yet what we do remains very much the same. Again, no one's discounting expertise. The question is, how are we leveraging expertise through process and technology? Because we're at the front end of this. We're at the front end of a technology curve that just gets steeper and steeper and steeper. And just because the growth of technology is inevitable doesn't mean our growth is inevitable. It doesn't mean that we are going to make the right choices to grow with it. It doesn't mean we won't be left behind. And that's as businesses or as individuals. We have a lot of choices to make, and we only have so much time, because time is moving forward, but also because we have to decide how to allocate our time. What are we going to spend our time on? How much time are we going to spend on getting better at technology? So again, I'm here in my Procertas capacity, and I'm happy to show what we do. There's laptops set up at the back, but before I do that, I want to open it up to questions, challenges. My favorite is when people tell me I'm wrong. But any questions on anything? I've spent a lot of time, especially as a consultant, inside a lot of large law departments, and then inside a lot of law firms of various shapes and sizes. It doesn't have to. Word is just the easiest example because it's so ubiquitous. Same with PDF and Excel, but it doesn't stop there. Those are just core technologies. Questions, comments, concerns? Really?
So I'm guessing you'll tell us this, but where do you find an outline of kind of get you from here to there on the big picture, and then obviously the details of implementing each of those changes in how you...
It depends on what you're trying to get good at. Whether are you talking about what is the suite of things that you're supposed to be good at, or are you asking, hey, how do I get good at Excel?
The suite, the bigger picture, such as Word, Excel.
It depends on your practice. I think there are probably 100 articles out there, of which I've written 5 on. Hey, here are the things you should look at. But it really depends on your practice. Are you in a large firm or a small firm? But most people are they're gonna live in email. And so in getting better at email actually can make a material difference in your life. They're going to be drafting documents, and they're probably, and then depending on what their practice is, they're either going to be analyzing things in Excel or creating a lot of PDFs because they have a lot of filings. That's where it starts, and normally on top of that, most people are dealing with some kind of matter management system, especially, whether it's Clio or my case at smaller firms. Larger firms, it tends to be a bundle of things in their document management system that can actually make their lives easier. But if they're at a larger firm, there's probably a knowledge management system they should pay more attention to. So it really depends on where you're at. But I would start there. I would start with email. Email and Word are almost universal, and then Excel and PDF. It depends, but probably good to get at those. And then all right, what are you actually using in your day to day? And then you should probably spend some time reading up on any of the security related to those. What do you need to do to make sure that you are maintaining client confidentiality? And that's not just about technology, that's about particular practices. Hey, I like to copy my Gmail account because the Gmail app on my phone is pretty slick, even when I'm emailing clients. Things like that. That's not necessarily technology, but it's technology adjacent. So whatever it is you see, what you use as those core technologies, there's going to be 5 articles on, or 50 on best practices related to security and confidentiality and privacy.
Yeah. Do you have a link or a list of 3 of the 50 so that I'm not up to date. So I used to have an index that I would circulate, but it's probably been 3 years since I circulated that. I should probably update it. But you know what a great resource for that is? Your local librarian, your local law librarian. So either the law library here, or if you work in a large firm, I would start there as opposed to with me. Is that correct?
It is. Actually, I was going to interrupt you just a second here because I know you like it so much, and suggest that you look at a list from lawyers.com that we printed off upstairs, and it gives you a breakdown. I think it's been updated in the last 6 months or so, and it includes things like productivity software, casing the Procertas product, covered Word, Excel, PDF, Adobe Pro, and other PDF programs, but more including the email options. So I'd be happy if anybody needs a copy, please stop upstairs and we'll provide that to you.
Other questions? Yes, sir.
This is a little specific, but I'm curious what you think most lawyers have problems with in PDF with the product. Adobe Acrobat.
There are many. I mean, the number one is redaction. I see that. I mean, that just because it's so dangerous and so common. There are so many issues that come out with redaction. But beyond that, it's not using it to its full capacity. And again, it depends on what it is you're doing. I mean, it's great for creating forms. It's great for if you, and this is one of those that most people don't know. So let me give you an origin story. My origin story. The very first day I got assigned to this case where it was the only time that I knew of that my firm was representing an individual versus a company. It was someone who'd been pushed out as the president and CEO of a company they founded, and they didn't get any money, and they're like, well, I'm owed a lot of money, which they were, but they were mortgaging their house in order to pay all the legal bills for this. So they wanted to make it cheap. I was cheap. and I got put on as the number 2 with the partner, and it was an amazing experience. I ended up 6 months into my legal career, second chairing an arbitration, doing depositions, cross-examining multiple people at arbitration, including key witnesses and experts. Amazing opportunity for me. But a couple months in, I was also in charge of all of the documents, of which nowadays it doesn't seem like a lot, but at the time it seemed like a lot. And my client said, hey, why don't you turn this into a PDF for me and send it to me? Oh, it was something we're looking at. I'm like, okay, print, walk over to the printer, walk over to the scanner, scan, come back, and his mouth is just open. I've been paying you to do that. Can't you just turn it into a PDF on your computer? Now, this is many, many years ago. Like, well, I don't know how to do that. Not only did I not know how to do it, the firm hadn't actually given me any of the software to do it. Because what did he tell me to look for? The PDF printer, right? Print to PDF. Well, here's the thing. That's actually not the best way to create a PDF. Microsoft Word has an export function. And if you use the export function to PDF, I'm just pulling it up, it's right here, export, create PDF. It will maintain things like hyperlinks and your document structure. So if you've structured the document to have a table of contents properly, it can, on the side, and just nerding out here, sorry. You see here, it can create bookmarks right here. Of course, I don't have any bookmarks right here. And then all of those are available in your PDF. And so you can make much easier to navigate PDFs if you do that. But PDF itself has bookmarking functions. Lawyers tend to be very bad at things they need to do, like splitting and combining PDFs. There's a lot of very basic functionality. Again, I have about 15 features that'll be in the software that'll show you. Those are the most common ones. But for me, the big one is redaction, just because it's so dangerous. I don't really want to call on you.
What are one of the things I used to get a lot from law schools, they would come to me and go, what is it that we need to be teaching students what we have done that will make them better, what you did? Are they doing anything better? I mean, my answer is always teaching Microsoft Office, PDF, and Cascade style sheets, and their style sheets. But I don't know, I've yet really to see someone come in that, if I say style sheets, that knows what style sheets are. It's something that we tend to teach them once we're here.
So my software is in use at 60 law schools now. The problem is that it tends to be used in specialty classes as opposed to being ubiquitous. So, and just so everyone knows, originally the software that I created, I tried to give away for free, and I've never made a dime from it. Everything we've ever gotten in has gone right back into development. I wanted to give it away for free. It turns out free is obscenely expensive. But the entire idea was to put it in law schools and have labs that people could do as part of the core curriculum. So in legal research and writing, you learn the basics of Word, and then in legal research and writing 2, you get a more advanced Word course. And then in civil procedure, you learn how to do PDF, right? You're putting together e-filings that conform to rules that we've now had for almost 30 years. And then in biz orgs or corporations, you learn how to do Excel. And in trial advocacy, you learn some PowerPoint. And you're not taking a class on Word. It's assignment that you do outside of class as part of that class that teaches you relevant skills to what you're learning in class. And so it's an add-on. We now have 60 law schools that have purchased licenses. It's less expensive than most of the legal treatises, and it's available to all their students. And we have some law schools that are amazing, and they have put every student through it. But most law schools, they give it to the person who teaches, the law and technology elective, that 14 people take. And it's great for those 14 people, but for the most, you're right, for the most part, most students still aren't getting this. There are some places where they do. We all know University of Oklahoma works hard on this as an example. And I use them because they're not a client. But for the most part, you're not getting this most places, and they should. And it's really silly that they don't. A, because it's insanely cheap for them, and it's so good for the students. And you don't actually have to change anything, right? You don't have to add a class. You don't have to decide what it is, what class are we not teaching anymore to make room for this. So that thank you for that softball, because this is one of my pet peeves. This should be available two places. It should be available in law school as part of the core curriculum, and it should be available as CLE for people who didn't get it in law school, or people who want a refresh, or because technology has changed and they want to. That's where it should be available, and law libraries, of course. But I am, and maybe this is unfair, I think it's too much to ask people to do it just on the fly all the time, carve out that time. We already have the CLE system for that specific purpose, saying we know it is hard for you to carve out time, so we're going to create a mechanism where you're automatically going to carve out some time. And I don't like piling on top of that. I like to be included in it, so kudos to Texas, for example, for accrediting us. And by the way, it's not just us, right? There's plenty of things out there that should be available as CLE. Other questions? Sir?
As an allied professional in a large law firm, how do you kind of move this needle along? I know you communicated from the top down, but just incrementally, how do you assist? Because I do a lot of work with trying to create better efficiencies for attorneys.
Well, as someone who's now in the role of an allied professional at a large law firm, I'm not sure there's a great answer. I mean, this is I remember the end of my Lean Six Sigma training. There was a question to the professor. You've convinced me this is great. I'm a lower level person in a large organization. How do I get my leadership to buy in? And the professor looked at him and said, I have no idea. Leadership buy-in is a prerequisite for a successful change initiative, not an outcome, right? It's an input, not an output. That said, I've found it's all about identifying champions, and champions aren't necessarily the person with the fanciest title. It's the person who knows how to get stuff done within the organization. If you yourself are not that person, it's identifying that person and convincing them. And it doesn't always take. Like, again, most change initiatives fail, and I don't have a magic recipe otherwise, other than identifying people who know how to get things done and convincing them to make this be one of the things that gets done. Although I hope some of you will agree that, I mean, once you see it, it seems obvious, right? I mean, people spend all day, every day in this software. It's convincing them that they're bad at it. That's the hard part. Other questions? Comments? Concerns? I don't know how we're doing on time. Oh, we're over time, aren't we?
Just now. That's why I'm slowly.
Oh, perfect.
In front of the room here. Oh, thank you. But no, so thank you, Casey. I really appreciate it. I just wanted to let everybody know we have Procertas set up back here on the laptops. If you want to take a look at the product and maybe ask Casey questions while we have him here from Austin. And CLE credit today is provided by the Harris County Attorney's Office. So if you didn't sign up for that, please make sure that you do on your way out. All right. Thank you so much for coming today.
This video is accredited by the State Bar of Texas from October 21st, 2019 through September 30th, 2020. Report CLE credit at www.texasbar.com using course number 174064321. Texas CLE credit for programs at the Harris County Law Library is sponsored by the Office of Vince Ryan, Harris County Attorney. And that's all there is to it. For more learning opportunities like this, including online tutorials and in-person training sessions, visit the Harris County Law Library's Legal Tech Institute website at www.harriscountylawlibrary.org/tech.